Hi, this is Nilgün Zahour from SM Juror, and today we're going to be looking at the juror misconduct issues in the case of State versus Hirsh, which is out of the Kansas Court of Appeals. Some points that I want to highlight that we're going to discuss are the procedure for recalling a jury, and also the fact that a juror need not volunteer information at voir unless they are specifically asked a question. In this case, the defendant was convicted of aggravated assault, criminal threat, and domestic battery. After the verdict, an alternate juror, DM, disclosed that several juror members were victims of domestic violence but did not disclose this fact during voir dire. According to DM's affidavit, one juror was abused in a prior relationship. Another juror had stated that her ex-husband put a gun to his head and threatened to kill himself in front of her. And a third juror had experienced domestic violence, but DM could not remember the specifics. The defendant filed a motion for new trial based on juror misconduct and a motion to recall the jury to investigate his claim, but the district court denied his motion. Now we're going to look at the specific question that was asked during voir dire, and remember that this is going to form the basis for the appeal claiming juror misconduct. So here's the question in quotes. As we discussed, some of these allegations are domestic violence allegations. Anybody feel by virtue of their experiences, their past, or past experience of a loved one that they can't sit fairly and impartially on this jury? Does everybody feel that they can put aside and sit fairly and impartially on this jury if they're chosen? Close quotes. So that's the specific question. And that's what's in the record. Now, district court has discretion in ruling on a motion for new trial based on juror misconduct. The standard of review is abuse of discretion, and a district court abuses its discretion in denying a motion for new trial based on juror misconduct if the defendant establishes that an act of the jury constituted misconduct and the misconduct substantially prejudiced his or her right to a fair trial. So there are two components: establish the misconduct and then show that it substantially prejudiced the right to a fair trial. Now, I want to emphasize that recalling a jury is an extraordinary measure that should not be undertaken lightly. The standard of review for a motion to recall the jury is again an abuse of discretion. If, however, a defendant's constitutional rights are implicated, then the district court has limited discretion to deny such a motion, and whether a defendant's due process rights were violated is a question of law over which an appellate court has unlimited review. Okay, let's take a look at the procedure for recalling a jury. Jurors may be recalled for post-trial hearings only by order of the court after a hearing on a request to recall the jury. A recall of the jury is not a routine matter. Jury service is a public duty of citizens, and the recall of jurors after their services have ended to testify as to events occurring in the jury room during deliberations is a serious step, and that step should only be undertaken for just cause. The procedure should never be utilized as a fishing trip upon a losing party's hope that jury misconduct might surface if the jurors could be questioned under oath. The burden is upon the party seeking an order to recall the jurors to show the necessity for the order. Now let's take a look at intentional deception versus no requirement to volunteer information. Though intentionally deceptive responses or non-responses do constitute misconduct, jurors are not required to volunteer information that they think or suspect may be of interest to counsel. And that's because potential jurors are not required to be mind readers. Juror misconduct must be based on more than the failure to volunteer information a potential juror speculates or surmises is important to counsel. Now let's take a look at the holding in this case. The Kansas Court of Appeals said that there was no error in the denial of the motion to recall. The defendant's conviction was reversed on other grounds. But here the court said that district court did not abuse its discretion in denying the defendant's request to recall the jury because the jurors were not required to spontaneously volunteer that they had personally experienced domestic violence without being asked. So remember, we looked at that question that was asked during voir dire, and it did not ask the specific question as to whether they were a victim of domestic violence. So there was no error here. Now, let's take a look at some specific facts which were pivotal to the outcome of the case. Here, the district court did not abuse its discretion in denying defendant's motion because he failed to establish that any juror misconduct occurred. Counsel never asked any of the jurors at issue whether they personally had experienced domestic violence or knew someone who had experienced it. So, the first strategy is to ask the specific question. He did not ask the question. 2, the 3 jurors that were referenced in DM's affidavit who allegedly failed to disclose that they had experienced domestic violence did not commit any misconduct because there's no indication that they ever gave any false or misleading answers to the court. So, the 3 jurors were not dishonest. And if they're not dishonest, there's not a basis for juror misconduct in how they answered questions at voir dire. And 3, the jurors were asked a general question about whether they ever had experiences in their own lives that would prevent them from being fair jurors. The court said the only thing we can discern from the non-response is that the jurors in question thought that they could still be fair and impartial. And contrary to the defendant's assertion, the jurors were not required to volunteer that they had experienced domestic violence without being asked. So, again, ask the specific question. Don't dance around the issue. Or, if you did dance around the issue, know that your basis for an appeal is not going to be very strong. Okay, and that's it for our case law analysis of the juror misconduct issues in this case. Again, this is Nilgün Zahour from SM Juror. Thanks for watching. Because the only evidence you want the jury to consider is in the courtroom. See you next time.